Thank you, Rachel. So, distributorship, dealing with divorce. Back to distributorship. It's a different kind of exposure. As I was mentioning a short while ago, the relationship is a relationship which you have with the distributor. You don't have the relationship with the customers, with the retailers in a particular territory. Your relationship is with your distributor in France, your distributor in Sweden. What that means is that if anything goes wrong, it's going to go wrong with one counterparty, the distributor. Your eggs are in that particular basket. And that in turn means that it's important, if you're contemplating a divorce, that you try and find out who the distributor's customers are. You can put into the agreement a provision which requires the distributor to inform you. You can put that in. You will find that quite a few distributors who are well advised will recognise that clause for exactly what it is and will argue that clause out of the contract. But if you don't try, you certainly won't succeed. So do try and find out beforehand who the customers of the distributor are. You may know. You may invite yourself along to the distributor's sales days, but try and find out. And try and find out insofar as you can informally for a reason that we'll come on to in a little while. Termination of the distributorship agreement. Grounds of termination. When Rachel was talking about the end, it's over, Rachel touched on the grounds of termination. In this respect, the grounds of termination for a distributorship agreement are not so very different to those for an agency agreement. We're looking at the issues of, has there been a material breach? Has there been a failure by the distributor to perform in terms of minimum purchase requirements? Has there been a change of control of the distributor? So you thought that the distributor was a particular company owned by a particular individual. He decides to sell. Are you happy with the new owner of the distributorship company? What happens when there is insolvency? Have you provided for that in your agreement? Have you provided for it by reserving title in your terms and conditions of sale? How Tumieto got it wrong. Tumieto is a textbook example of how not to bring a distributorship agreement to an end and what not to do thereafter. Tumieto was or is a US footwear brand. He decided to appoint a distributor here in the UK. Initially, the relationship was extremely good. It was the honeymoon period. The brand owner decided at some point that it would actually make sense to try and put in place a formal agreement between the parties. That starts the toing and froing. Formal agreement comes over, west to east, across the Atlantic. Something goes back, but it's different, east to west. The parties do this on a number of occasions over a number of years, never actually agreeing what is going to be their agreement. But meanwhile, the agreement is continuing, the relationship is continuing. Orders are being placed each season. Orders are being delivered each season from the US to the UK. Ultimately, they get to a point in time where Tumieto thinks, as is often the case, it can do better without the distributor. Fine so far. So it decides to end the agreement. It doesn't take advice, or if it does take advice, it doesn't get very good advice, or if it does take advice and it does get good advice, it doesn't listen to the advice that's been given, all of which are possible, but it gets it wrong. And the next thing we know is that the distributor has brought an action in the High Court against Tumieto. And this is where Tumieto really get it wrong. Because now they're defending an action. And now they're defending an action where they've actually got no real good reason, no particular complaint about the distributor, other than we probably thought we could do better if we didn't have the distributor and got on with it ourselves, which doesn't really go down that well with High Court judges. So what do Tumieto do? They try and engage in legal reverse engineering. they cooked up various arguments, literally cooked up various arguments, as to why they were justified in bringing that particular agreement to an end. The distributor wasn't performing. Well, actually, it's pretty easy for the distributor's barrister to stand in front of the judge and refer him to the pleadings, which show that actually, year-on-year performance has improved. Okay, that's not going to work. The distributor could have done better. Well, as we've looked at the figures, and the figures are going in the upward direction, if they started from a low enough base, then okay, the incline's good, but they don't go very far. Perhaps that would work, but no, again, on the facts, it's not working. The distributor didn't deal promptly with inquiries. The distributor can show that it did deal promptly with inquiries. If you remember what Rachel said about not returning a call in respect of an agency termination, it doesn't really work. And the distributor, terminator went on along this particular course, and it couldn't particularly point to situations where it had complained about the distributor's performance. So the judge had no difficulty in saying, no, I don't accept that, that doesn't work. I found Mr. Smith an unreliable witness, Mr. Smith being a witness for the brand owner, Tamieto. And when a judge says an unreliable witness, what the judge is actually saying is that he found Mr. Smith to be a lying bastard, Bidron said. Result, Tamieto got it wrong, the distributor won the case. It won the case hands down. We'll come back to Tamieto in a little while. Consequence of termination. Starting point is you should actually provide in your distributorship agreement what are to be the consequences of termination. Is the distributor going to have a right to sell on the product that it's already holding? Are you happy for that to happen? Should you not be taking back control of a particular territory which the distributor was representing? Possibly. If you are going to take back the stock, do you want to have the obligation to take back the stock or the right to take back the stock? Because then it's up to you as to when you choose, whether you choose to take back or not. There is a difference between obligations and rights. If you're going to take back the stock, what are you going to purchase it at? Well, it's possible that you got the termination of the distribution wrong and you're going to face a claim for damages. Possible. Are you therefore going to face a claim for having to pay out the margin that the distributor would have earned by selling the stock? Have the distributor been allowed to sell it? Are you going to factor that into the price at which you buy back the stock? Or are you going to buy back the stock at wholesale? What's going to happen there? It's up to you to determine how you provide for that. What about unpaid amounts? Is the distributor up to date in all the amounts that it owes you, both for forward selling and for stock orders that it's placed? It goes on from there. What is important is that you provide in your agreement for what is to happen in terms of the consequences of termination. Yanseng, an international trade corporation. This was a case decided in about March of last year. It's rapidly come to be one of my favourite cases. It involved Yanseng, a Singaporean distributor of, wait for it, Manchester United Fine Fragrance. Yes, I know what you're thinking. More's the pity, as they say, but I'll leave you to think about that. Yanseng was persuaded by International Trade Corporation to become its distributor in various parts of Africa and Asia. I say persuaded because arguably International Trade Corporation kicked off and said it was the licensee of Manchester United for Fine Fragrance, when in truth it hadn't yet been appointed as the licensee and actually couldn't appoint distributors to be its distributors for something for which it wasn't the licensee. So the relationship arguably didn't kick off on the best terms, but we'll brush over that. Yanseng and International Trade Corporation actually enter into an agreement. I referred before to writing an agreement on the back of one side of the fact packet. This was a better agreement. It was written on one side of a large A3 envelope. It set out various provisions. The parties actually tried to put something together which resembled an agreement. And then it started to go wrong. And it wasn't a case of getting knocked out of the Champions League, which may be happening in a few hours' time. Sorry, Rachel. It was the case that International Trade Corporation made various representations to Yanseng. It told it that it would be supplying. It gave it a territory in which to act as a distributor, and then decided to sell itself in that territory. It failed to deal with inquiries. It got to a point in time where Yanseng said, we can take no more of this, and they terminated the agreement for breach on the part of the supplier, arguably the brand owner as against the distributor in this case, and they went for damages. And they argued, or it was argued on behalf of the distributor, that International Trade Corporation owed it a duty of good faith. And if you think back to the point that Emma made at the start of this afternoon about this concept of good faith, one of the provisions which the regulations will imply into the agency relationship, we see the crossover now from agency to distributorship. Arguably, it was Yanseng's lucky day. Arguably. Why? Because since Yanseng we have had 3 further cases where the courts have turned their back or sought to limit the concept of good faith in a distributorship relationship. But for the purpose of Yanseng and International Trade Corporation, it was Yanseng's lucky day. The judge was prepared to entertain the concept of good faith operating in a distributorship agreement, and was satisfied on various counts that international trade had failed to fulfill its obligation of good faith to its distributor, Yanseng. Result, Yanseng wins, International Trade Corporation loses. The issue of goodwill, and this is another aspect to show how we get closer from agency to distributorship. And I put on the slide a movement closer to agency. And it is, because we've seen in Yanseng this concept of good faith used. Yanseng actually, I think they ended up with the equivalent of 9 months worth of damages. So the judge said, had the relationship continued, then they would have continued for another 9 months, and therefore the profit that would have been earned during that period of 9 months will be treated as the damages for the distributor. We've seen that also in Jackson and Tum Yeto, where, if you remember, Tum Yeto tried to reverse engineer the reasons for termination, got nowhere. And again, in that case, the judge ends up at a period of 9 months. So there begins to be a pattern developing here. Although in that case, it was the situation that Tum Yeto, having said we were right to terminate, then sought to argue that the period of time should be given by way of notice was effectively next to nothing. Jackson sought to argue it was, I think, 18 months worth of notice that it should have been given, and the judge Plain Solomon said, right, 18 place 0, divide that by 2, and we get to 9. You see the way judges' minds work. And I put also onto the slide Belgium, Germany, Switzerland and Spain. Why? Because it is the case that Belgian law does in some situations provide greater protection for distributors than it does for agents. And you've heard what Emma and Rachel have said this afternoon about the protection afforded to agents. Germany. It is the case that the German Supreme Court has extended German law which protects agents also to protect distributors in certain situations. Switzerland, in 2000 and it was either 9 or 10, the Swiss Supreme Federal Court decided that a distributor was entitled to a goodwill payment equivalent to that of being an agent. And Spain. Spain does entertain the concept of distributors being compensated on termination. Yesterday I was notified of a new Spanish case where the distributor actually failed to get compensation, but failed because of the particular facts of that case, clearly showing that in principle the distributor could have got compensation. And what is it that links Belgium, Germany, Switzerland and Spain is not a historical question. What links it is the fact that what the courts and what the laws are looking at in each of those countries is the fact that the brand owner is getting at the end of the relationship with the distributor the details, the knowledge of what or who the customer base is in that particular country, which takes us back to the first slide of this particular session, where I spoke about the knowing who the customers are of the distributor. And it follows that if you're in a situation where you've got a Belgian, a German, a Swiss, Spanish distributor, or for that matter, a distributor in other parts of the world, Brazil is a prime example, you can be faced with a situation where the local law does protect the distributor. You can be faced with a situation. You can find ways of getting out of that situation. But if you are faced with that situation, you may well find that the protection afforded to distributors isn't so very different to that afforded to agents.